I'm going to just switch over to share a PowerPoint screen, and we will launch this slideshow. And here we go. Okay, so as mentioned yesterday, well, thank you very much for joining us again today. Again, we've got a intimate group, which is wonderful. So I encourage you to, if you want to keep your microphones off so that when the phone rings and the kids run in the room, that it's quiet. But if you have a question, just take your mic off and jump right in there and interrupt me anytime. It's very possible that I can say things in a confusing manner, and I'd like to make sure that I clarify things on the spot before we get too far down the road. As I mentioned yesterday, there's a little bit of duplication in some of the concepts near the beginning of this presentation. I'm going to run through them really quickly when we get there, but I'm going to try not to take up too much time. Our goal is to finish before 4 o'clock today, and we're going to take a 10-minute break at 2:30. And so if I'm not watching the clock and you guys want to start waving at me and bring it to my attention that we're getting close, then we'll do that. But as mentioned yesterday, we've got the legal aspects of staffing and legal aspects of recruitment are the two sessions for yesterday and today. We've got health and safety sessions, business practices, ethics, and recruitment and selection. There's a new module that is being introduced for the first time that is in staffing industry sales that can be done in replacement of the recruitment and selection, or you can do both in order to get your CPC, but you need 5 modules in order to qualify to write the exam. We talked yesterday, and we'll do at the beginning of every session, one of these training sessions, about the industry association's mission. But basically it is to identify and monitor industry standards and business practices. We want to influence all of those people that have some effect on the industry, whether it's regulatory practices, our customers, or the business environment that we work in. We need to promote the credibility of our own businesses and of our competitors, because the reputation of one affects the reputation of all. And of course, ACSESS provides a whole variety of services and programs, including the CPC program and conference. While I mentioned conference, just pay attention to some of the emails or go online. There is a annual conference in the month of, I think it's May of 2025, that will be held in Montreal. It is a 2.5-day conference that is exclusively for the recruitment and staffing services industry. It's the only full-on industry association conference that you're going to get in Canada that is specifically designated for you. There's going to be all kinds of great speakers there. It's a wonderful opportunity for a learning experience. So if you're an owner or a manager, then think about going yourself. Think about making it a maybe an award or a prize or recognition for some of your top performers and some of those people you want to help with their professional development. And if you're an employee that doesn't get to make those decisions, you don't ask, you don't get, then go to your boss and talk about whether or not this is part of your professional development that they'd like to make a contribution towards investment in for you. So hopefully we'll see you in Montreal in the spring. Today, we're going to talk about human rights legislation, and we're going to talk about discrimination and all the legal aspects around recruitment and how human rights work. We're going to explain how we apply some of this to our hiring practices. We're going to then move on to diversity and DEI, and we're going to talk a little bit about that. And then, of course, if we're going to finish off with privacy legislation and how that what the legislation means, how it works. And of course, at the end of this, we're going to try to be prepared to write our exam, but we're going to commit to uphold all of these legal aspects in the operation of our business. So again, big picture for today, we're going to talk about human rights. We're going to talk about DEI, employment equity, and privacy. 4 critical components to recruitment that I'm going to tell you that people that don't take this course, other human resources, people in the industries, hiring managers in companies that are maybe specialists in their thing, but not in human resources. These are things that people think they know, but often are a little misguided in terms of their understanding of what it means, how it's applied, and what their obligations are in order to do their recruitment properly in the context of these laws. So let's first start off with human rights. So human rights describes instinctively, sorry, I'm just going to move some stuff off my screen here that's really blocking things up. How we instinctively expect to be treated in what we're all entitled to. And we want to think about human rights as dignity, respect, and equality. And it's equality of opportunity, not treating people the same. Okay, so when we talk about equality at work and in business, we say, hey, do we give them the same opportunity? Do we have the same policies? Do we have the same practices? Doesn't mean that everybody is exactly the same, because they're not the same. Some people are better performers than others. Some people are smarter than others. Some people have more experience than others. Some people, just have been around, have more years of experience in the company. So, but we talk in the context of those three areas. Now, as we mentioned yesterday, there are federally regulated industries in Canada. Of course, the federal government falls under federal regulated industries, and also banks, telecommunication companies, airlines. We mentioned a bunch of industries yesterday that basically go across borders, that it's almost impossible to think of them in the context of being a regional company. So we want to have the same policies, practices, procedures, understanding of rules and legislation and regulations in every province in Canada, because that plane flies across those borders, and those tracks move across the borders, and those trucks move. Oh, by the way, not all trucking companies, transportation companies are federally regulated. If they're a transportation company that only does local transport in the same province, then they can be provincially regulated. But if they move across interprovincially, then they must be federally regulated. So we've got federally regulated industries, and we've got provincially regulated industries. Basically, everybody who's not listed as federally regulated, so everybody else is provincially legislated. And so as a result of that, we have federal human rights legislation that applies to those industries. And we've got provincial, different, substantially similar, but differently worded provincial legislation in each province. So the Human Rights Code in the province of Quebec is not worded exactly the same, and doesn't necessarily deal with things exactly the same as they do, say, for example, in Ontario, Manitoba, or New Brunswick. There is the Federal Human Rights Act and the Provincial Human Rights Act. They have different names sometimes. For example, the Canadian Human Rights Act is the name of the federal legislation. Each provincial legislature has a statute, has a different name. So in Ontario, they call it the Ontario Human Rights Code. I don't know why sometimes governments call it acts and other call it codes. I'm sure there's a reasoning behind that, but sometimes you'll have, for example, the Employment Standards Act in Ontario, and you have the Employment Standards Code in Manitoba, and they're almost exactly the same. We talked yesterday also about the Charter of Rights and Freedoms, which is under the part of the Canadian Constitution. So the Canadian Constitution, under the Charter, kind of sets the high level standards, saying these are the kinds of things that need to be covered, and these are the kind of things you have to have laws for. And if you don't have laws for them, they're going to be covered somehow in common law. And so each of the provincial the federal government writes its Human Rights Act, and each of the provincial governments write their Human Rights Code to be in keeping with two principles. One are the principles set through the Charter of Rights and Freedoms, and the other is through common law. All of the decisions that have been made by courts in the past, then when they go to write their legislation, they try to encompass those decisions that have become common law. And of course, those are all passed in the federal House of Commons or in each provincial legislature to become a statute. So I'm not going to go back and forth now between federal and provincial because they're intended to do the same thing. Just one's written to apply to those industries, and the other is written to apply to the provinces and those industries. But they're intended to do the same thing, and they are fundamentally the same with some different wording. So the penalty for breaching it might be a little bit different, or the manner in which an investigation is handled or a complaint is handled might be a little bit different, but they pretty much do exactly the same thing. So in the context of recruitment, when we think about human rights legislation, we think about advertising. How do we write that ad? Do we put some words in that ad that might imply some form of discrimination, or does it apply to everyone equally? When we're dealing with referrals of candidates, we can, I'm going to get into systemic discrimination later on, but if we are only hiring people through referrals and we only have people of a particular group in our company, it's highly likely that we're going to get lots of people from the same group. So if there's a family-owned business and they are of a particular religion and they start to hire family members, nieces and nephews and son-in-laws and daughter-in-laws, and then they start to hire their grandkids, and then the company grows and they start to take referrals of their contacts, there's a pretty good chance that their referrals are from the same schools and the same churches and the same community. And there we are through a process of systemically, we're now only even considering people within the same group. So we're actually not including people from others. Did somebody type something into the chat? I just saw a pop up there. We're all good. Everybody's good. Okay, good. So things like promotions and demotions, they are covered under human rights. Things like who we offer our training to, when we offer our training, how we offer our training can have some issues around human rights. How we set our wages for all of our employees can be affected through human rights. Okay. Hello, Deborah.
Hi.
How are you? How you doing?
Good. How about you?
Pretty good. We're kind of about 10 minutes into it, so I'm not going to review those things, but you're welcome to stay on at the end. And if
No,
we
no. I've been on since virtually the beginning. I just didn't want to interrupt you when you talked about recruitment
uh,
advertising, and I can wait my questions to the end if you prefer.
no, you jumped right in there. I'm sorry I didn't see you on the list of
That's
things on my
okay.
screen, so that's okay. So yeah, you have a question?
Yeah, I put it in the chat there. I'm a direct hire recruiter in Ontario, and I'm curious in the recruitment advertising for my direct hire positions. Can I ask for 4 to 6 years on the job experience? That's part A. Or is that age discrimination to the younger generation? And part B is, can I also say it needs to be Canadian experience? So, for example, our accounting rules or civil engineering with the Ontario Building Code is different than what it might be in another country.
Sure. Um, the answer to that is yes, probably. I'm going to explain it to you now, and we're going to get into it even more detail in a few minutes.
Okay.
So we look for what's called a bona fide occupational requirement. So if there's, say, for example, um, you have to have knowledge of Ontario building codes and standards, and you think that 5 years or 6 years of experience with Ontario building codes and standards is necessary in order to perform the job, then I would just simply be careful that you say exactly that. That you say knowledge of Ontario local and municipal, Ontario provincial, local and municipal building standards with a minimum of 5 or a minimum of 6 years experience in dealing with such standards. And so that becomes what's called a bona fide occupational requirement. In other words, it's the word bona fide is means that it's real, it's substantial, it's proven, it's not just an opinion. And some people say bona fide occupational requirement. And so if that's a real qualification that's necessary for the job, then it's okay. Even if it implies that a person under the age of 22 or 23 or 24, or 25 might not qualify for that job. And it's sort of systemically discriminating against people under the age of 25 or 26 because they needed to go to university or college and get their certification, and then they needed to have their 6 years of experience. But it's okay to have that standard and to, in fact, have the appearance of discrimination if the reason for it is what is called a bona fide occupational requirement. So when we're writing ads, recruitment ads, advertisements, we sometimes are concerned about word count and space and size. And so we write it really vaguely, must have 6 years of Canadian experience. Well, at the end of the day, that's probably not going to be a problem. You're not going to see too many people complain about it. But in order for it to really be presented appropriately, to remove yourself from that, just be more specific. Because if you mention what the bona fide occupational requirement is, then people understand that you're not discriminating against young people. You actually are looking for a reason for something that is a qualification. It is a qualification that will make you included. You're not using words to exclude. You're not just using words to exclude a group, if that makes sense. And I'm going to talk about this a little bit more, or maybe not so much, a little bit more because I just explained it. But when we get to those screens, and hopefully that'll help you out. And also, Deborah, thank you for typing it into the question. But there's this real small group, so just do what you did. Take your mute off and jump in and ask the question when you want to ask the question. And then when we're done, you can put your mute back on and away we'll go.
Thank you.
So hopefully I answered your question. Application forms are always a problem. People, purchase application forms, they download application forms, they put things on application forms. And, you got to understand that an application form is kind of probably covers all of the jobs in your company, as the sort of basic form. So be careful about what kind of information is included in an application form so that you're not eliminating people on prohibited grounds. The questions we ask in interviews, I think that people should really go through some kind of interview training, because we unconsciously, subconsciously ask questions that maybe didn't feel like it was intended to be discriminatory, but we're setting the person up to give an answer, which now provides us with information in a under prohibited grounds. And, so if we were to say to somebody, hey, are there any reasons that you want to explain to me why you may not be able to work after 5 o'clock, a couple times a week? And so the person, oh yeah, I'm married and our car and my husband or my wife picks me up and our kids have daycare. And, all of a sudden, a person's giving you an answer that might cause you to subconsciously discriminate or make them think that you're discriminated against them based upon family status or something. So, we just need to be careful about our interviews. Of course, things like apprenticeships. Isn't there a movie where the retired executive becomes an apprentice? I think. So we're not supposed to be discriminating against people on our apprenticeship based upon age, for example. Transfers. So pretty much every matter that's relating to employment or prospective employment can probably be looked at in the context of human rights, discrimination, prohibited grounds, bona fide occupational requirements, and so on. So discrimination is an action or decision that treats a person or a group of people negatively for reasons such as their race, age, or disability. These reasons are known as grounds of discrimination. And there are 11 grounds that are protected under the Canadian Human Rights Act. And we're going to look at each of those 11 grounds. And we often call them grounds of discrimination or prohibited grounds. And they include, and let me just flip through them all so I get them all. They include race, nationality or ethnic origin, color, age, sex, sexual orientation, marital status, family status, disability, and we're going to talk about it a little bit more. A conviction for which a person has been granted or a record has been granted a pardon, or a record of has been suspended. I'm not sure if we have more slides on that, so I'm just going to deal with that one right now. So when you can ask if you have a bona fide occupational requirement that a person is free and clear, that they're trustworthy. So you're putting, say, for example, they're going to work in a bank and have access to bank accounts. They're going to work for a credit card company and they're going to have access to people's credit cards and credit information. They're going to work in accounts payable, accounts receivables, and they're going to have access to checks and writing checks and processing payments and setting up accounts for payments and so on. Then you could say, hey, it's really important this person doesn't have a pattern of behaving in a criminal fashion, because they could easily steal from us. They need to be trustworthy. And so you could say that those jobs have got a bona fide occupational requirement to be free and clear of any criminal convictions. Now, a pardon is when a person's been criminally convicted and they've paid their dues, they've gone to jail, they've done their parole, they've applied to the government and said, hey, like, it's been a long time. Can you wipe this off my record? And so a record can be suspended for some reason. Like, say, for example, there's an appeal and they go, hey, that person actually wasn't, that conviction is being appealed and it's overturned, or a pardon, they paid their price. So we're not supposed to be able to ask a person, have you ever been convicted of a criminal offense? The question is, have you ever been convicted of a criminal offense for which you have not been pardoned? Okay. And of course, we can't ask that question and shouldn't be asking that question if they're laying sod or if they're sticking cotton into bottles. Now, if they're sticking cotton into bottles and those bottles happen to contain fentanyl and they've been convicted of drug dealing in the past, well, maybe that's an a bona fide occupational requirement that they have not been convicted, because they've got access to this, these medications that could be stolen just the same as money could be stolen and cause harm to the community or people. So deciding what's a bona fide occupational requirement is first, and is a criminal conviction a bona fide, not having a criminal conviction a bona fide occupational requirement, knowing that a criminal conviction that has been granted a pardon is not really a criminal conviction anymore. It's not information we're allowed to use. So let's move that one up. So here's an interesting story that kind of, oh, by the way, you're going to see some examples today that are from the 80s and 90s on here. And the reason why they're on here is because they're the case precedent setting court decisions that got us to where we are today. So laws have changed and decisions have been made, thousands of them since then, but we're using the examples in here to tell you how we got to where we are today. I could
Steve, I'm sorry
list.
to interrupt you. I just have one question. So, like in many of the jobs, is it okay to ask for a criminal record check or ask our, the temp staff to temp hires to get the criminal record check done?
If the job they're being sent to has a bona fide occupational requirement that they need to be clear of a criminal record, then you can ask for it.
Okay.
So if the job is laying sod or working in the mine and they never get access to cash, people's credit cards, they don't have the opportunity to steal valuable things, so you might, if they work in the mine and they're going to have access to explosives and they've got a criminal record for being a pyromaniac, then I think that you could say, yeah, that's a bona fide occupational requirement. Why did you put a pyromaniac into the explosive shed? So you need to look at the actual job and ask yourself, what are the things that are legitimate that we can use for requirements on this, which we refer to as a bona fide occupational requirement. So if they don't have, if you're not at risk, an obvious risk, I don't mean like, listen, anybody can steal from anybody at any time. Like, you can't say, oh, it's a bona fide occupational requirement because all of our employees carry wallets and they could, jump them in the parking lot and steal their wallet. That's not a bona fide occupational requirement. It has to be a function of the job, has got a specific risk that is known to the risk is of valuables or danger or something. Can we attach a requirement to that job to make it, I'm going to using my fingers, if you can't see my fingers, bona fide, then it can become a requirement, and then you can do a criminal background check, or then you can do a credit check, or then you can do a medical check. But if the requirement doesn't require them to be healthy to do the job, you can't do a medical check either. You can't ask them to go to get a doctor's certificate that they pass, a drug test if there's no risk of them being on drugs that's going to cause a danger to people. So I think that if you're going to drive a school bus, you could say, yeah, I think you got to have a drug test.
My understanding was if the client requires it, and again, I'm a recruiter and I've been in the temp world for a few decades, but now I'm exclusively direct hire. My understanding is if the client requires it and they expect their own full-time employees to do medical or criminal background check, then we can have the same expectation of the candidates. Is that correct?
Yeah, sort of. It is part of the process of you saying, is this a bona fide occupational requirement? And you're just, if that's the only standard you have, then you just should be careful, because if the client is violating the law and they're doing criminal background checks, or they're doing drug tests, or they're doing some kind of, credit check, that's not a bona fide occupational requirement, but they're just out to lunch and they're doing it wrong and they should never have been doing it in the first place. And if their employees went to the Human Rights Commission and said, hey, wait a minute, this is inappropriate, you're just jumping on their coattail and doing the same inappropriate thing. So what I'm saying to you is, understand what a bona fide occupational requirement is. Understand the concept of a bona fide occupational requirement. Understand what the real needs of the job are. What does the person do? So then the customer says to you, we also have to have a medical background check. We have to have a credit check. We have to whatever. And you have to look at the job that is what they do. You ask yourself, is it reasonable that this is considered to be a bona fide occupational requirement? And if they are, then you say, sure, absolutely no problem. If they're not, if they're laying sod, if they're out there doing landscaping and they say we got to do a credit check and a background check and a personal police check and this check, then if you know that and you say, okay, we're going to do all these checks anyways, then you're kind of participating in a violation of human rights. So you should have that conversation with them. And you can say, hey, you know what? What's the bona fide occupational requirement? How do we do you mind if we we'll do the reference check, we'll do the verifications of accuracy of the resume and stuff. Can I leave that medical check and the criminal check up to you? Because we don't see the connection. We don't see why I'm supposed to be looking into their bank records to be a graphic designer. I don't see the connection. So if this is part of your hiring process and you can establish it's a bona fide occupation, can I take it? I'll do everything except for that one. Is that okay with you? And they might say, yeah, sure, no problem. And if you do participate in it, you either got to find some bona fide occupational requirement, or you're making a conscious decision to participate in a process that is not in keeping with human rights. And I would suggest that you don't do that. Also, just so you know, I ran a company with 22 offices, 550 recruitment desks. We place 7,000 people a year into jobs. I never had the problem where a customer was asking us to do something that did not have a bona fide occupational requirement to it. But I did meet customers who discriminated, and we had to deal with it, but usually not on the credit check, background check, kind of stuff. Okay. So in this particular case, with LGBTQ, the original Charter of Rights and Freedoms did not list sexual orientation when it was written in the charter. When we rewrote, we had the BNA Act, and then we wrote the Canadian Constitution and included the Charter of Rights and Freedoms all the way back to Pierre Trudeau. And it was not, sexual orientation was not listed. There was 10 listings. But over time, courts looked at common law marriages of same-sex couples, and they started granting, in common law, decisions in favor of same-sex couples. And as a matter of fact, a friend of mine, Doug Elliott, in the 1990s, went to court and fought on behalf of the Canada Pension Plan and spousal death benefits for same-sex married couples, and won. And so in 1998, the courts decided that the provinces should include sexual orientation in there, just the same as it said sex, but sexual orientation was also, the courts decided that the provinces should include it in their legislation. And then, so that became like a common law decision. And then in 2000, 2 years later, the federal government came along and passed Bill C-23 to put it into statute, to write it right into the law, which gave same-sex couples the same social and tax benefits. So the CPC death benefit, for example, and married benefits for tax deductions for married benefits, and that sort of thing for married couples, to heterosexuals in both common law marriages. And then they took it one step further 5 years later to say, hey, same-sex couples don't have to necessarily have lived together for 4 years or 5 years or 3 years or whatever the standard would be to try to have a common law marriage. Let's let them also actually get a piece of paper and get married. And so they enacted another statute called the Civil Marriage Act in 2005, which was the milestone when same-sex couples were allowed to get married with a marriage certificate. And so this is a perfect example of how the Charter wrote the big law, the Charter of Rights and Freedoms, and the Canadian Constitution wrote the big law, saying these are the principles that we need to adhere to, and all laws should adhere to these principles. And then there were not statutes in place, and so courts started to make decisions saying, in keeping with the principles of the Charter, these are the decisions we're going to make. And then the House of Commons and the legislatures came along and said, well, these decisions have been made pretty consistently in common law, so let's write it into a statute. Let's vote on it and put it right into law. So it's unambiguous. And then they went even further by making more laws. So first off, it was same access to benefits. And then the second part was, we're going to actually allow same-sex couples to be married and get marriage certificates, trying to remove those barriers of discrimination out of the way and make it really clear what the intentions of the laws are supposed to be. So we've got this concept called adverse effect discrimination. So sometimes a policy or a practice can unintentionally single out a person, or can single out a particular group of people, and as a result, give them unequal treatment. This type of unintentional discrimination is called adverse effect discrimination. So some examples of adverse discrimination might be requiring employees to wear promotional uniforms that conflict with a person's religious clothing. So in the province of Quebec now, currently, in and out of the court, lots of fights. The provincial government doesn't want government employees to be wearing religious jewelry or symbols or emblems. And the federal government's got some issues with that. And so they're arguing against it. And the unions have got some issues against that. So this has been going on for years in the province of Quebec. Some people are trying to say that this is systemic discrimination. I'll get back to that in a second. That they're basically trying to promote Catholicism, the Catholic religion, by banning all other religions from promoting themselves in the workplace, in government jobs. Others say, hey, let's just be equal to everybody and let everybody, wear their, as long as it's not a safety issue. So it's a current issue that's going on in lots of places, Quebec being one of them that seems to get in the news a lot. Establishing work schedules that uniformly rotate employees in a rigorous and rigid order that interferes with a person's religious holidays. So, every third day you have to work, and then all of a sudden it falls on we're going to look at an exact example, 2 examples of this in the next couple minutes. Standardizing office furniture and equipment that maybe don't work for people of a particular size or shape or disability or injury or something, and not accommodating. So there's other types of adverse effect discrimination that could exist. And we're going to come back to the differences between adverse effect and systemic discrimination. So the one we hear about in the news a lot when they talk about the RCMP or the military or CPC, we hear these complaints and these court cases where groups of people say, hey, there's a set of policies where this organization is systemically discriminating against a group of people. So when discrimination happens because there's a business practice, a workplace policy, or a program, a government program that people are adhering to, we call this systemic discrimination because the discrimination is not limited to a single incident or occurrence that people couldn't have envisioned, like the rotating policy thing. This is like literally a system or a process that is eliminating or giving to a particular group of people, or maybe giving preference to another group of people. And so a large group of people would be affected by it. And this type of discrimination, systemic discrimination, the reason why we hear the term in the news a lot is because it's of interest to the Human Rights Commission. So they've got a normal way to do things in the workplace that may have a negative impact on some groups of people. So some examples of systemic discrimination might be this criminal background check or credit check, the examples that we talked about earlier. If we are only looking, if we're doing credit checks on everybody and how much money your family makes or made, or whether you borrowed money to go to university or to come into the country or to get your first home, these things may imply a bunch of things, but they may have nothing to do with the job that you're going to perform. So recruitment practices just favoring word of mouth. So we talked about the referral aspect of systemic discrimination earlier. Steering of applicants to certain jobs or assignments based upon their race or gender. So we might say, women should be teachers or nurses, men should be truck drivers. I mean, these are all forms of systemic discrimination. Historically segregated occupations or industries. So again, engineers, for example, probably in the 1940s and 50s and 60s, there were far more men in the engineering field than there are today. So these would be forms of, if we had held these beliefs and we had any kind of policy that moved people that way, or we considered people in that way, this would be called systemic discrimination. Job ads showing preference to, so the example we talked about earlier, you know, if the question is young or energetic or recent or men or women, that's systemic discrimination. The example we had earlier was must have 5 years experience in working with Ontario building codes and particularly familiar with some of the unique aspects of the Mississauga building code that might have some unique aspects. I don't know, from the Toronto building code. These could be considered to be bona fide occupational requirements. And so we don't say no young people allowed. We say only people with this experience allowed, which in fact might eliminate some young people because they wouldn't have had an opportunity to get 5 years experience. So if it's a bona fide occupational requirement, fine. If the job ad says recent graduate and energetic, you got to ask yourself, why does it have to be recent? Is there something that people learn now in school that they couldn't have learned in school 10 years ago and then got better on the job? I mean, I think, for example, in the recruitment and staffing industry, I've been around this industry for 40 years. And I've run companies with thousands and thousands and thousands of people. Literally have been led organizations that have, in over the years, billions of dollars in sales. I've hired thousands and trained and managed salespeople. So would a recent graduate have more knowledge and experience than me in a sales job in the recruitment and staffing industry? Don't think so. So the term recent graduate would be implying I only want young people. Then maybe I can pay less to. So you can say, hey, people willing to accept a salary of this range, that's fine. But suggesting that they need to be recent graduates would be systemic discrimination. To the question earlier, not the same question, but the customer says I've got a preference towards something. If it's discriminatory and we have a system of accepting the customer's standard, then that could be considered systemic discrimination. If the customer's preference is bona fide, it's not systemic discrimination. Sometimes big data can throw us off. We can look at some algorithms and big data and say, oh, only people that fit into this number or whatever could actually be discriminating against some people. Some personality and tests or profiling tools could discriminate against some people. Physical ability tests, capacity tests, cognitive tests, if it's not a bona fide occupational requirement, what is it telling us? Mandatory religious practices by employers. So, I don't know. I think, for example, if you want to be a nun, you should probably be Catholic. If you want to be a teacher in the Catholic school board, I think that's been challenged. I don't know nowadays. I know that years ago, in order to become a teacher in the Catholic school board, you had to get a letter from your priest to say, yeah, you're Catholic. But I'm pretty sure there's some jobs working in the Catholic school board that have no significance whatsoever, whether or not you're Catholic or not. So having mandatory religious practices by an employer could be considered, in most cases, would be considered systemic discrimination. But of course, there are bona fide rules. So English only could be a problem in some jobs, maybe not in others. Age-based limits, mandatory retirement policies, waivers that prevent an employee from filing complaints. If you take this job, you don't have the right to complain. No, not good. No fault attendance policies. So, there used to be, I think there's sort of like the, you're 3 strikes and you're out. You missed 3 days of work and you're done. Well, we talked yesterday about those things that people are actually written right into the statute, into the Provincial Employment Standards Act now. saying, hey, people are actually entitled to take time off because their kids are sick and their mom is dying. Their child was abducted. People are actually allowed to do this because employers came along and said, well, we have a no follow attendance policy. You're late 3 days, you're fired. You're away 3 days, you're fired. And of course, the government had to come along and say, hey, that's wrong. And so they started to write things into. So having those kind of policies without any kind of understanding towards some of the grounds of discrimination that are protected in law take away the right to have a no fault policy. Light duty policies for only work related injuries. So, you know, the workers this is where people get workers' compensation return to work and human rights confused. So if a person is injured and has a temporary disability, we have an obligation to accommodate them. If a person is injured at work and can't come back to their job because they can no longer perform that because they have got a workplace injury, then we actually have penalties and things associated with our workers' compensation claim. So we try to accommodate them into another job, into another place, maybe give them a clerical job so that we can reduce the cost of our workers' compensation insurance claims, which will reduce our penalties or increase our rebates. That's different from a light duty policy where a person is doing a job. They were hired to do a particular job and then they have an injury. So we say, okay, we don't need to necessarily move them over there, but can we change the nature of their work so that a disabled person or an injured person or a sick person can do some of that work? 100% healed to return to work, same thing. You know, can you do the job? Doesn't necessarily mean you're 100% healed. Pre-employment medical inquiries, again, if they don't have a bona fide occupational requirement, they can be considered systemic discrimination. So those are examples. What are the differences? Let's just kind of review between adverse effect and systemic discrimination. Well, adverse discrimination could be a good policy, and it may be unwittingly or unintentionally have the impact on a person or a group of people, a negative impact of people. However, it might be a good policy, and it just might require that occasionally it has an unintended effect on a person. So we ask, okay, how can we accommodate this person without turning the whole policy upside down? So it might be a furniture policy. Say, hey, we got a furniture policy. Everybody gets exactly the same chair. They get the same desk. They get the same light. They get the same stapler. And then we have a person with a disability and we say, okay, do we get them a different chair? Or can they have a desk that's a little bit higher or lower to work with a wheelchair? So if we say, no, you can't have this job because you have a wheelchair and our desk is too low and you can't roll up to it, well, that would be adverse effect discrimination. And the policy was to save money and to be equal to everybody, and then it didn't work for somebody. So you make a reasonable accommodation, which is very different from systemic discrimination, which is not a good policy. It systematically and regularly influences or causes a discriminatory outcome. So when we have systemic discrimination, that's the ones we hear about in the news, change the policy. I've talked a lot about this already. Accommodation. So accommodation is a reasonable accommodation is an adjustment made to a system to accommodate or make fair for some people that may have not seemed fair on the face of it. And accommodation can be because of religious beliefs, or it can be about academic standards, or somehow employment related. So a reasonable accommodation, for some examples, could be, I don't know if the first few are great examples, but let's just say, for example, we're doing all of our recruitment on Indeed, and yet the Aboriginal community in our area just never looks at Indeed. They don't go to Indeed. They've got their own Aboriginal community websites and postings for jobs. And so if we only ever advertise on Indeed, but we know that the Aboriginal community locally uses a different process, let's advertise there sometimes. So these job advertisements, if we're looking for people that don't necessarily have to speak English, but we only advertise in English. We could be discriminated against people of different languages because they never read English advertisements because they don't speak English. They don't read English. So if the job doesn't require English, why do we always advertise in English at the same place? Apprentice programs towards people with disabilities. Sometimes they're older workers. Sometimes we just don't even consider them at all. And we've got some rules about who can apply. Installing software features or keyboard equipment to accommodate people would be considered an accommodation. So the example I gave you about the desk height, or putting in software that has got voice to text for people that have got visual impairments or have got other disabilities that mean they can't use a keyboard. Changing the schedule to accommodate a person's religious practice. They cannot work, say, for example, after sundown on Fridays. And yet you're running a retail store that's open on Fridays, and you always seem to be putting this person into Fridays and interfering with their religious beliefs when they could have worked on Saturday night, for example. So a bona fide occupational requirement, we talked about this. By the way, in the United States, they call it a bona fide occupational qualification. And in Canada, we tend to call it a requirement. So when you hear BFOQ or BFOR or bona fide occupational requirement or bona fide it's qualification, same thing. It's a quality or an attribute that employers are allowed to consider when making a decision on hiring because it's legit. And in the absence of this legitimate need, it would be considered to be a discriminatory practice. So let's look at some cases. I'm going to go through them quickly. It's not important that you memorize these cases. And again, these cases are old, but the reason that they're on here is because they are the precedent-setting first cases. There have been thousands of them since, but they very often will say, oh, in the Christie Dairy Pool case, Mr. Judge, we use this as an example of why you should agree with me today. So Mr. Christie was employed at the dairy pool. You've got to remember this was 1983, so the technology was probably a little bit different, and became a prospective member of the Worldwide Church of God. The church recognizes Saturday as their Sabbath and 10 other holy days throughout the year. Members of the church are expected to not work on these holy days and on Saturdays. Mr. Christie asked his employer for permission to take unpaid leave on Tuesday, March the 29th and Monday, April the 4th in 1983, because both were religious holidays in his church. He was granted leave for the Tuesday. His employer said, yeah, okay, you can have Tuesday off. But nah, man, you can't have Monday off because Mondays are super busy here at the dairy pool. Milk that arrives at the pool on Saturday and Sunday must be processed on Monday, otherwise it'll spoil. So nowadays, the whole manner in which we collect milk, we store milk, we homogenize milk, we keep milk cool. Dairy farms put it right into cooling systems and homogenize it and process it right at the farm. Nowadays, they don't ship it to places far away and sit warm waiting for 2 days. But in 1983, it went to the dairy pool and it got processed, and stuff that came in on Saturday could not sit until Monday. But Mr. Christie was absent on Monday, April 4th, without permission, took his religious holiday off, and so the dairy pool terminated his employment. The Board of Inquiry ruled that Mr. Christie was discriminated against because his religious faith had not been accommodated. So they said, so the first court said, it doesn't sound like you tried to accommodate this guy very much. You're wrong. But the dairy pool appealed it and went to the Court of Queen's Bench, the higher court, and then went to the Court of Appeal to another higher court, and the original case was overturned. So the Board of Inquiry originally found that the employer made no significant effort to accommodate the request, and that there was no specific, they called it fatal, to the establishment of a bona fide occupational requirement, a bona fide occupational qualification. Thou shalt always work on Mondays because of the spoilage of milk. So it got overturned. And they said, oh, okay, you didn't discriminate against him. So if we were to sit here and have a conversation and then go back and read all the minutes of the court decisions, clearly if it got overturned, the dairy must have been able to say, hey, we have, I don't know, we have 6 employees. We need to run a super long shift, 12 hours, not 8 hours on Mondays, because we got to process Saturday and Sunday's milk and Monday's milk. So we run for 12 or 15 hours on Mondays, every Monday. This is really important. Otherwise, we lose hundreds of thousands or thousands of dollars worth of milk that spoils if it doesn't get handled. It's a health hazard to the community. So they obviously went back and they proved that there was a bona fide occupational qualification or a bona fide occupational requirement. Otherwise, this thing wouldn't have been overturned. And so the first court obviously wasn't convinced that there was a bona fide occupational requirement. Maybe in the presentation to the first court, the employer didn't think that they needed to very much, so they didn't present a lot of information. So if it is that a bona fide occupational, could the charge of religious discrimination be defended by proving that the employer attempted to accommodate the employee? Or did they accommodate the employee on Tuesday? They said, hey, it wasn't unreasonable for us to accommodate you on that other day off because it was a Tuesday. We didn't need to have all of our employees working 12 or 15 hours that day. But it was unreasonable for us because of the burden it would put on other employees or onto a spoilage of milk or something on the Monday. So clearly they were able to establish that they made some effort to accommodate him by giving him Tuesday off, but giving him both days off was unreasonable. And so these are the kinds of conversations that are had by employers and their employee groups and by the courts. Case number 2, 1985, precedent setting again. First case on this one. I'm old enough that I actually remember this happening. So the CN Railway was charged with discrimination, and the Supreme Court of Canada decided that the requirement of wearing a hard hat was not a bona fide occupational requirement and amounted to discrimination on the basis of religion, which entitled the Sikh worker to continue his employment without having to wear a hard hat. So the Sikh worker wanted to wear his religious headgear, and the employer said, no, take it off, put on the hard hat. They tried to fire him, and the court came back and said, no, that's, in this particular case, you don't need to do that. And so Mr. Binder, what they were able to establish was this. That first off, there was a lot of maintenance electricians that worked for CNR, right? That for the Canadian National Railway. They had a lot of maintenance electricians, and he wasn't the only one. And so they could pick and choose from different maintenance electricians to work in different places around the yard or around the trains or wherever they worked, around the work facility. And some places didn't necessarily require a hard hat. And then Mr. Binder was not unique or specialized. He wasn't like the only one who was doing that job, so they could probably have accommodated him by asking other people to go in certain places. The courts decided that the employer's safety policy would not be in jeopardy. In other words, they wouldn't say, oh, geez, you're good. You do this for one, you got to do it for everybody. They said, no, this policy's not in jeopardy. That if we allow Mr. Binder sometimes to not wear a hard hat in some places, that's not going to cause every employee to say all the time that they don't need to wear hard hats. Mr. Binder was willing to relocate to a post where a safety helmet was not necessary. So there obviously were some places where there was no threat of getting hit in the head. So he was not willing to assume duties other than that of a maintenance electrician. He didn't want to go be an administrative clerk working in the office, but he would accept a relocation to a place where there were no risk of head injuries. Mr. Binder was able to perform effectively and efficiently without the hard hat. So it wasn't like you had to say, hey, you got to wear these things in order to do the job. You got to use our gadget to do the job properly. If you don't use our gadget, the job won't be done properly. The helmet didn't fit into that sort of category. Neither Mr. Binder's fellow employees nor the general public would be necessarily at greater risk of being injured if he relocated to these new spots, if he failed to wear a helmet. And so the risk of injury to Mr. Binder did not exist or was negligible. So once they went to the Court of Appeal and they looked at all of these things, lots of people could do the job, lots of opportunity to move people around, lots of places where you could do the job differently without having head injuries, doesn't affect his performance, doesn't affect the policy overall, that this could have been accommodated, and that in the first case, when the court decided that he could be hired, they were wrong and they overturned it. So which of the following is not a discriminatory practice? So here's a question. Denying someone goods, services, and facilities to accommodate based upon a prohibited ground. Which of the following is not a discriminatory practice? Denying someone goods, services, facilities, or accommodation based upon prohibited grounds. That's discriminatory. Denying employment opportunity based upon a bona fide occupational requirement. That is not discriminatory. If it's a bona fide occupational requirement, you can say to somebody, you can't do this job because it's bona fide. Paying men and women differently when they're doing work the same, that's discrimination. Retaliating against a person who has filed a complaint with the commissioner, that's discriminatory. Harassing someone, that's discriminatory. So the only one of these things that is not discriminatory is denying employment to a person because there was a bona fide occupational requirement and the person could not meet those requirements. So last example, Western School Director. It was a unanimous decision that the Supreme Court of Canada restore the decision of the BC Council of Human Rights, which found that Mr. Smith was discriminated against by his employer and his union on religious beliefs. So this one is similar to the hard hat one. Mr. Smith was a custodian in a school. He was a Seventh-day Adventist. His religious belief prevented him from working from sundown on Friday to sundown on Saturday. The work schedule required him to work on Friday shifts from 3 p.m. to 11 p.m., which was set out in the collective agreement. This had to do with the fact that the schools rented out the schools in the evening to groups. So the school was open to Cub Scouts or Girl Guides or floor hockey league or something, or the choir, or somebody rented the school gym or something on Friday nights. And so you had to have a custodian on duty. The BC Council of Human Rights found that it was a bona fide occupational requirement for a custodian to be present in the schools, but it was not a bona fide occupational requirement that it would be Mr. Smith from his own school working that shift, that it could be any custodian from any of the schools came to Mr. Smith's school. And so originally they found that he was not discriminated against, but through the Court of Appeal, they said, hey, look, you could accommodate this guy by allowing him to not accept a shift and allowing a custodian from a different school to come over and work that shift if they accepted it. And that was a reasonable accommodation. So there's an example of a bona fide occupational requirement. Somebody must work there. Yes. Bona fide occupational requirement to be the same custodian from the same school. No, it could be any custodian who knew the policies, practices, and procedures in the school system. And so they could reasonably accommodate that, that second requirement. So not a bona fide occupational requirement. This one, I think that this might be the last time we're going to keep this slide here as an example, because Hockey Canada has had so many bad decisions. They've made so many bad decisions. They've been in the courts. They've been sued. They've lost their funding. You know, I'm pretty sure that some of these policies have changed since then, but this was a precedent-setting case that gives us an example of what we should do or not do. So Hockey Canada agreed to make changes to protect young players in Ontario from discrimination and harassment based upon the players' transgender status. These changes resolved around a human rights application filed after facing difficulties at several local arenas. A resolution was made between the Human Rights Commission and Hockey Canada that agreed that Hockey Canada would provide training to all of its Ontario-based trainers and coaches on gender identity and gender expression, including training on discrimination and harassment. So in other words, Hockey Canada came back and said, yeah, we haven't done a very good job of making people aware of our obligations and understanding how this makes people feel and how we should be dealing with, understand the law. And it would amend its co-ed dressing room policies, which would be publicly posted on their website and in the various arenas and so on, that said that a player has a right to choose a dressing room that corresponds to the player's self-identified gender. Player shall be addressed by the player's preferred name and referred to by the pronouns corresponding to the player's self-identified gender. And a player is entitled to privacy and confidentiality with respect to the player's trans status, and information about the amended policies information about the amended policy accessible to staff, volunteers, parents, guardians. So basically, we're going to take these policies and we're going to make everybody know that we have these new policies. So if I remember correctly, teams in various hockey leagues were saying, hey, this is a male, has to play in the male league, or this is a female, can't play in the male league. But the person identified as a he instead of the female wanted to play in, but also wanted to have some issues with respect to privacy around that. So wanted to have access to co-ed dressing rooms opposed to necessarily being forced to be in the female dressing room or the male dressing room. Lots of confusion. So they came up with this policy to alleviate that confusion and the problems. Now, by the way, Hockey Canada has had so many other court cases since then. I'd be surprised that the policy placed then is the exact same policy they had now. But that was an example of how things can happen. Okay, so let's just take a look at some of these ones before we move on. So this is sort of like a review of some of the things we talked about before. A policy provides benefits to some married couples, but not to other couples. This may be a case of discrimination based upon family status. So family status, one of the prohibited grounds. Number two, a person is identified, a person is denied a job because of previous conviction for which a pardon has not been granted, or a record has not been suspended. So this one has to do with the pardoned conviction. Now, by the way, a person can be denied a job because their previous conviction had not been granted if the job had a bona fide occupational requirement for that. If they were denied the job and there was no related bona fide occupational requirement, as I said to you, the landscaper was denied the job because they had a drinking and driving offense, but they never have to drive on the job and they can get to and from the job, then that criminal conviction cannot be used. It would be considered discriminatory. So it falls into the category of pardoned convictions. Number 3, an employee has a reaction to dust and chemicals at work and needs to take 2 days off. The employee needs the company's address for the workers' compensation WSIB forms in Ontario, WCB in other provinces, Workers' Compensation Board. Forms to be filled out by his or her doctor. You guys know this if you know your health and safety. An employee is injured at work or gets sick at work or something affects them at work. We need to fill out a Form 7. We need to submit it. Then the doctor at the doctor's office has to fill out a Form 6 or 7, 5, and they submit it. And these forms should collide and say the same things at the WSIB when they're assessing the claim. Sometimes people don't know that it happened at work, so it only is filed by the doctor. Anyways, her supervisor refuses to give the information so the doctor can fill out the form. Or the employee asks for certain information, and the supervisor refuses to give the information because the employee is told that there is no place for her to work at the company because they don't want her filling out workplace safety forms and workers' compensation forms all the time, basically implying we don't want to have these claims, we don't want to have this record, so we're not going to give you the information to fill out the forms. Well, that is not right. And that is discriminating against a person because of their disability. So the allergy is considered to be a disability. And their systemic policy of not providing information so that they can't make claims would be a violation of human rights and also of the workplace health and safety laws. A female employee with an excellent performance record announces that she is pregnant, and immediately her employer begins to identify performance issues that lead to her dismissal. This is maybe a case of discrimination based upon family status. An employer assigns her employees to weekend shifts without recognizing that some employees observe the Sabbath and cannot work on those days or on one of those days. This may be a case of discrimination based upon religion. And employers' physical fitness requirements are based upon the capability of an average 25-year-old instead of being based upon the actual requirements for the job. This may be a case of discrimination based upon age. Is harassment a form of discrimination? The answer to that is yes. It's a special kind of discrimination called harassment. And quite frankly, it doesn't matter what the topic of harassment is, whether or not it's under prohibited grounds or not. In most provinces now, they have defined harassment in their human rights code as being a form of harassment. And as a matter of fact, in Ontario, they've further codified it by putting it into the workplace health and safety legislation to also be considered harassment, that a person being harassed in the workplace is no longer considered to be safe. So harassment occurs when someone makes an unwelcome remark or jokes about a person's race, religion, sex, age, disability, or any other grounds of discrimination. And as I mentioned to you, so it's a human rights violation, human rights code violation, if it's under the prohibited grounds. But Ontario and other provinces have taken it even further by making a workplace health and safety violation if the harassment is just any kind of harassment that goes beyond this scope, because human rights only dealt with prohibited grounds. And so now workplace health and safety said this is no longer a safe workplace if it's some other form of harassment. So if it threatens or intimidates a person, it's considered to be a harassment. If it makes unwelcome physical, if a person makes unwelcome physical contact, such as touching, patting, pinching, or punching, which could be considered harassment. Now, by the way, under the in business practices and ethics, we're going to deal with this in more detail, particularly under the definitions of harassment, types of harassment, and we're going to get into the workplace health and safety about, does it have to be repeated incidences, or is it one incident? Is there a time limit to file a complaint for harassment? And the answer is yeah. A complaint for harassment must be filed within 12 months of the last alleged event. So it kind of goes like this. If there are a few events and you don't make a complaint, and 12 months go by, your complaint will not be heard by the Ontario Human Rights Commission. If there are several events that are considered to be harassment, 12 months go by, and then there's a new event, you can make a complaint about this new event within 12 months and include everything prior. So the complaint must be made within 12 months of the most recent event, but all the events don't need to be within 12 months. So the example was several events, 12 months go by, missed the window. Several events occur, 12 months go by, a new event occurs, the complaint is now made within 12 months there, and of course you can't see my hands off screen. All the previous events can be included as evidence in the allegations. Multiple choice questions. Identify and select answers below that does not constitute harassment. Discrediting the person by spreading malicious gossip or rumors, ridiculing him or her, humiliating him or her, calling them questions into place. A single or isolated incident, such as an inappropriate remark or having an abrupt, first off, discrediting a person by spreading malicious gossip isn't necessarily considered to be harassment. Not necessarily considered to be harassment unless it deals with one of the prohibited grounds under human rights. If it does fall under human rights, it is. Now, along comes a single or an isolated incident, such as an inappropriate remark or having an abrupt manner. That is not necessarily considered harassment. It is only considered to be harassment if the event is so grievous, so significant, that one time in itself could consider to be harassment. So, touching someone on the shoulder, not harassment. Touching somebody on the shoulder, patting them on the butt, putting your arm over their shoulder, doing something, being asked not to, multiple incidents, yes, harassment. Making a significant, serious, material, and obvious sexual comment that could be so grievous that the one event is considered to be harassment. Now, still a violation of the Human Rights Code, but it wouldn't necessarily be considered to be harassment if it was touching and somebody says, hey, don't touch me anymore. And you say, oh, sorry, I didn't mean to be that way. And then they don't do it anymore. That doesn't fall under the classification of harassment. It's wrong. It doesn't fall under consideration of harassment. Unwanted sexual advances may or not be accommodated by threats. That's harassment. Making rude, degrading, or offensive remarks on a consistent basis, harassment. Friendly gestures amongst coworkers, such as a pat on the back. Just gave you that example. Not necessarily harassment unless it's repeated. And the person's asked not to, but not appropriate, but not necessarily considered harassment. Isolating the person by being no longer talking to them or denying, ignoring things. So the friendly gesture is not necessarily, all the others are considered to be harassment. Okay, so the term quid pro, what time is it? 5 more minutes, we're going to take a 10-minute break. The term quid pro quo is a Latin term that means this for that, something for something in return. It's not necessarily a human rights issue. As a matter of fact, they've talked recently about U.S. Superior Court judges, Supreme Court judges getting free trips and free plane trips and holidays and houses bought and sold for people's mothers. This is what they would consider quid pro quo. It didn't have anything to do with human rights. It was wrong. So quid pro quo means this for that. It's on the face of it, the term doesn't mean that it's wrong, but it is used in legal terms to often describe things that were wrong, where somebody offered something in exchange for something that was inappropriate. And so in the context of human rights, it usually has to deal with sexual harassment. So examples would be in the workplace when a manager or other authority figure offers or merely hints that he or she will give the employee something, a raise or promotion in return for the employee's satisfaction of a sexual demand. So sexual harassment. Changing work standards after an employee consistently refuses and repeatedly requested to go out on a date. Sexual harassment. Discipline or firing a subordinate who ends a romance. So people in workplaces often should have policies about not having a workplace romance. It's not against the law, but when people do it, the problem arises when special consideration is given to people who are involved in the romance, or penalties, discipline, or bad things happen when the romances don't work out. That would be considered quid pro quo. A job applicant who also may be subject to some kind of harassment if the hiring decision was based upon the acceptance or rejectance of sexual advances. Obviously, sexual harassment. So the term quid pro quo in the context of human rights is often used to describe sexual harassment, but the term in itself can be used in many other contexts, such as, hey, it could be, quid pro quo could be in the barter system. Somebody might belong to a barter group saying, hey, you cut my grass, I paint your fence. That is quid pro quo. In that particular case, probably not used in a negative way. But if somebody was trying to figure out that you didn't pay your taxes, they're likely to use the term quid pro quo by accusing people, saying they didn't declare the benefit that they received through quid pro quo. So it's not often used in a positive context. In the context of human rights, it's often used in the context of sexual harassment, which is a form of harassment, and it is a violation of human rights. So the act in itself is the principle that all individuals in Canada should have an equal opportunity to make for themselves the lives they are able and wish to have, and to have their needs, their special needs, accommodated in order to have those lives that they wish to have. The Human Rights Act is meant to promote this equality by prohibiting discriminatory practices based upon specific attributes such as race, ethnicity, sex, etc., the 11 prohibited grounds, which may hinder or prevent a person from doing so. These quotes are taken right out of the Act, Federal Act. Okay, before we move on to our next topic, which is going to be diversity, equity, and inclusion, part 2 is now 2:30, right on the nose, so we are right on schedule. We're going to take a 10-minute break. Again, like yesterday and other sessions, I encourage you to not leave the room and try to come back in. That tends to have some problems. Just keep yourself muted, keep your camera off. I will mute my camera, and I will see you back here at 2:40, and we will try to be done a minimum of 10 minutes early today. So if we get back on time, we'll get done early today. That's your quid pro quo for being on time, used in a positive context. Let's see you at 10. I mean, for example, with respect to DEI, recently we've heard um, inappropriate criticisms by one particular person running for president of the United States of Kamala Harris, and they accused her of being a DEI selection. In other words, inappropriately suggesting that because of policies that exist, people have been inappropriately promoted and elevated in their careers or in their work through DEI. And certainly that is not what DEI is. It is not the intention of DEI at all. And so we're going to look at the Canadian context of DEI and start off with the Federal Employment Equity Act. So first off, it's important to understand that the Federal Employment Equity Act, so when you hear the term employment equity or the Employment Equity Act in Canada, it is referring to a particular and specific piece of legislation, not the general concept, but a particular piece of legislation that is for federally regulated industries, so the federal government, airlines, banks, trains, telecommunication companies, that is intended to deal with some of the discrepancies that have existed historically with respect to the percentages of employees who are women, people with disabilities, Aboriginal people, and people with who are visible minorities, and how it reflects to the percentage of people in the hiring population. So the Employment Equity Act is intended to deal with this discrepancy where, say, for example, a company might have less than 50% of its working population women when the people in the community that they work in, women represent 50%, or that 10% of the 15% of the people in the community have disabilities, and a smaller percentage of people that work in the company have disabilities. And so, the question might be, particularly with respect to disabilities, Aboriginal people, and visible minorities, and women, are there areas, manners in terms of the process in which companies hire that might be causing this? And so, we'll read the exact words. I just explained it, but to achieve equality in the workplace so that no person shall be denied employment opportunities or benefits for reasons unrelated to ability, and to correct the conditions of disadvantage in employment experienced by women, Aboriginal people, persons with disabilities, and members of visible minority communities, to be giving effect to the principle that employment equity means more than treating persons in the same way, but also requires special measures and to accommodate those differences. So it doesn't mean that we give special preference to a person that fits into the group in one of these 4 groups. Does not mean that. It does not mean that if you've got 2 equally qualified people applying for a job, that you must or should hire the person from the designated group. It does not mean, really does not mean that you've got 2 candidates or 5 candidates and one person fits into one of those groups, and so they get priority in hiring. What it really does is it suggests that, is there something about the way that we attract those 4 designated groups to apply for jobs so that they have an equal opportunity to be considered to be the best candidate? Doesn't mean we're going to hire somebody from a group when they're not the best candidate. It just means, are we doing something in the way that we run our company or that we attract candidates that means that we get a disproportionate number of people that don't fit into those groups, and somehow creating barriers or not giving access to people in those groups so that they can be considered for that hiring? So we also have, the federal government also has a thing called the Provincially Regulated Suppliers Program, or the Federal Contractors Program. And so this means, for example, recruitment companies and temporary help companies, when they've got over 100 employees working in their organization and they're given a contract for $1 million or more, this really is applicable to, say, for example, temporary help companies. So you're given a $5 million contract to supply, and you're a provincially regulated company, and you're supplying people to the federal government. Then we have to ask the question, is the supplier adhering to the same kinds of standards, and can they participate in this program so that their workforce can reflect the objectives of their customer, the federally regulated customer? There is no, in Ontario or in Alberta, there is no provincial program that is equal to the federal government program, but there is the federal contractors program, where the suppliers who are supplying a lot are asked to participate in the program. So, it looks like this. You can go online to the federal government, you can find the federal government contractors program, and here's what the objectives are. First is to conduct a workforce analysis. So we collect data about our workforce. What percentage are women? What percentage are men? What percentage have are people with disabilities? What percentage are Aboriginal? What percentage are self-identified visible minorities? And then we do a review of our employment systems. Is there something in our systems that is creating a barrier or not creating equal access? And of course, when we do step number 1, we conduct a workforce analysis. We also have to have an analysis of the community. So we need to know, we need to go out there and say, okay, what percentage of the people in our community are Aboriginal? What percentage of our workforce is Aboriginal? Then we conduct a systems review to look and say, all right, is there some systems in place? Then we set out a plan, and the plan sets some goals. It says, we need to move the needle one way or another somehow. So we're going to put out a plan that says, over the course of the next 2 years, we're going to identify things that we can do in our cafeteria to provide certain types of food to people, because certain visible minorities might not want to come to work there because there's nowhere else to eat except for in the cafeteria, but we don't provide them with the food that they like to eat. So they never apply for jobs here because they know that we can't accommodate them that way. So then we create this plan, and then we establish and sustain this employment equity program by documenting it. And then every year we submit an annual report to the federal government saying, okay, this is where we started. This is the things that we identified that we could probably fix. We developed a plan that said these 3 things are going to be fixed within the next 12 months or 24 months. And these other 3 things are in the next 24 months after that. We execute the plan, step number 4, and we submit a report to the federal government once a year telling them how everything's gone. So an employment equity involves all of the following except for what? No, sorry, let's click on that. So identification of systemic barriers to employment opportunities that adversely affect designated groups? Yes, it's supposed to identify those barriers. Does it include government imposed quotas? Does not. The government does not tell us that we have to have 50% women and 50% men or a certain percentage. It does not give us quotas. It just says, have a plan, take a look at your workforce, take a look at the community, create a plan to try to remove barriers. That's all it says. Plan to overcome employment barriers? Yes, it does. That we should provide some forms of reasonable accommodation to help overcome some of those barriers? Yes, it does. Be proactive in planning an annual employment equity plan? Yeah, that's the plan. So what it is not quotas. So, let's just, ask a couple of questions. We're not going to have the long conversation today, but what are two major demographic pressures affecting the Canadian labor force today? One, the large number of baby boomers approaching retirement age. That's one. The shortage of young people available to replace them, particularly the shortage of young people who are pursuing trades. That's one. We also hear a lot about, like we asked for two, immigration. Immigration can be an issue. Do we have enough people immigrating to Canada with the skills that we require to fill certain kinds of jobs? When we are allowing people to, is there enough housing? Is there, what about English speaking jobs? Are we able to accommodate people with different languages? There's all kinds of topics that can come up that affect the labor force, and sometimes, if not managed properly, if the issues are not contemplated well, can end up in forms of barriers for discrimination and can disequilibrium in our workforce. Another aspect of DEI in Ontario, which has to deal with disabilities and the concept of codifying, creating statutes or laws like the Federal Government Employment Equity Program, is AODA, Accessibility for Ontarians with Disability Act. The Act speaks to developing, implementing, and enforcing accessible standards in order to achieve accessibility for Ontarians with disabilities with respect to goods, services, facilities, accommodation, places to live, employment, buildings, the structures, the premises. And this was implemented, I think, in 2005, and it had a 20-year horizon, 2025, with milestones for each section of it. So way back in 2025, when it first started kicked in, we had an obligation to train our employees with respect to customer service in understanding what it meant, what the definition of a person with disability was, and what it meant, and how we could provide accessibility to buildings, languages, disabilities for people with vision impairment, with audio impairment. So are we allowing people to hear our policies? Issues around notifications on our website. So customer service was the first phase of the OADA program. Then we got into information and communication. So how is it posted? Where is it posted? What mechanisms do we use to communicate with our customers and with our employees and with the community? And then we were to look at employment barriers and how we could affect improved employment, removing employment barriers for people with disabilities. The fourth stage, so each one of these things was further down in the timeline, in the 20-year timeline. So transportation is a really obvious one that we all see. So now we all see these buses, leaner buses, tippers, I don't know what they call them, so that they come up to the bus stop and then they lower and the steps come down to the ground so there isn't such a high step. Some buses, certain percentage of the buses have got access for wheelchairs. A lot of the, I'll tell you a story. So here's a story. So, and how things can sometimes work out and not work out. So we're all familiar with Wheel-Trans and Trans Help, it's called in Peel region. So it's wheelchair accessibility for mini buses for people that can't get onto public transportation. I have a 30-year-old daughter who's been in a wheelchair all of her life, and she's got cognitive and other disabilities that go along with that. And so she was taken to school when she went to school. She had a special bus that came to the house and picked her up in the community, and it had a wheelchair lift and took her to school. And then when she finished school, we got her a pass with Trans Help, which is called in my part of the country, but it's called Wheel-Trans in the other parts of the GTA in Greater Toronto. And they're integrated so that people can go from one system to the next system. And, you phone and you can use voice activation or other activations to order a Wheel-Trans to come to the house, and you pay, $4 or whatever it is, the normal price for transportation, but you get accommodated that way. And along came the AODA, and so the Peel Mississauga Transit started introducing regular buses that had accommodation for wheelchairs. And one on here, Ontario, one of the main arteries, one out of every 4 buses or something can take a wheelchair, and it lowers down, and it's got places you can clip your wheelchairs in. And so all of a sudden, the Mississauga Transit denied her access to Trans Help, because they asked the question, do you have to have an aide with you? And the answer was yes. They said, well, if you have to have an aide with you because of your cognitive impairment and your mobility, then you should be able to go on the regular bus, because the aide can help you on the regular bus and clip you in and all that kind of stuff. And, then we said, well, wait a second, it's like 2 kilometers to the closest bus stop, and there's winter time, and she's in a wheelchair. And we have no sidewalks in our neighborhood. Are you saying that in the month of February, they have to go through the sleet, the snow and the ice with no sidewalks, 2 kilometers, and then wait for every 4th bus that comes by, sitting out there in sub-zero temperatures, to wait to get on a bus so that she can go to her doctor's appointment, that she can't phone Wheel-Trans? And they said, yeah, AODA, we now offer this, to make it accessible for everyone. Well, in her case, that actually didn't work out, right? So we asked for reasonable accommodation. So they came back and said, okay, between the months of April and October, you're required to use public transportation. And from November to March, you can use Wheel-Trans. We'll come to the house. So, that was their approach to reasonable accommodation. And to have, in their case, to think to have that Wheel-Trans come to the house in June was unreasonable for her to expect that. So this is exactly, so AODA required the municipalities by law and businesses by law to have transportation designed in such a way to accommodate people with disabilities. And then all the other issues with respect to reasonable accommodation, bona fide occupation requirements, all that kind of stuff applied in the same way. And so there's an example of how AODA affected transportation in, I think, for most people in a real positive way. And in the case of that I just gave you, it didn't work. And so it was an adverse effect discrimination because of the wintertime issues and the sidewalks. And so they applied the concepts of reasonable accommodation to make it work. And then, of course, the final phase, which they gave 20 years to get into place, was the built environment. So that has to do with physical facilities, elevators, ramps, buildings, slopes, curbs, steps. And they said, okay, like usually about once every 25 years, most offices have some form of renovation. Just make sure that when you do your renovations and your moves and you're building new buildings and so on, that you can accommodate this built environment. And then, of course, people can make applications under heritage applications saying this building should not be substantially changed in order to accommodate that because it'll undermine the heritage value of the building. So the built accommodations. So, you know, the reason why AODA came into effect and why other provinces and jurisdictions have similar legislation is that 1 in 7 Ontarians, if you ask them to self-identify, has a disability. That 95% of those people, it's not an obvious demonstrative disability. It's considered to be a hidden disability. It's estimated that 1 in 5 Ontarians that are 65 or older, and half of that group will have some form of disability. So our population is aging to 1 in 5 over 65, and half of those people over 65 has some form of hidden or obvious notable disability. More than 500,000 Canadian adults have some form of vision loss, like broken glasses, and that's not corrected by glasses. And more than 1 million live with some form of hearing loss. And of course, it's really difficult. These are not obvious things that a person has vision or hearing loss. So we ask people to identify themselves in a lot of cases at work so that once they've self-identified, then we can take corrective action to try to accommodate them in a reasonable way. And, you know, you can't talk enough about the issues of mental illness and the effects on Canadians, either directly or indirectly through their family, through their work, through their family members, their friends, their colleagues, their marriages. Mental health issues range everything from PTSD to anxiety to the whole slew of identifiable syndromes, mental health issues that are come through chemical imbalances and cognitive impairments and head injuries and head traumas, all the way through to aging with Alzheimer's, dementia, and others. And so mental health issues take many, many effects. And personalities that are not considered to be exhibiting characteristics of mental health illness range so dramatically that it is almost impossible for us regular old folks, without having intimate knowledge and experience with a person, to know what type of effects their mental health is having on them. Is it just that this person has got a personality trait that seems pretty out of the norm? Or is that out of the norm reaction or behavior or understanding of things through mental health issue? And so we can't assume that people have mental health issues, and we also can't assume that they don't. And so whenever we have got a performance issue at work or hiring issues at work, we run into a little bit of a challenge. And this is not going to be a question on the task, but you know, when we're interviewing people, we're not allowed to ask questions about their mental health or about their disabilities. But when we do hire people because we think they're the best candidate and they declare to us, or we become aware of their disabilities, including mental health, we've got an obligation to accommodate. And I can't emphasize this more, and this is not to preach to people, that's not the purpose of this session, but we become better companies. We become better customer service providers. We become more capable of providing better products and services to our customers and to our community when we take into consideration the needs of our employees. When we, you know, when we hire people from different diverse backgrounds, when we accommodate people with disabilities and mental health issues at work, we start to get a better understanding and perspective of the needs, wants, desires, fears, hopes, capabilities, and limitations of different kinds of people. And we just become better companies. We make better stuff. We deliver our services in different ways. We have more patience and understanding of the reasons why people act and communicate in the way that they do, and our businesses thrive from it. So we've got a moral obligation to try to accommodate and help people in need. We've got a business advantage that we achieve when our moral obligation, our legal obligation, and our business goals all align with each other. We become more profitable, we become better places to work, we have better employee retention, we have more customers, we provide better services to our customers. So it's not just because we're doing the right thing for the right reasons, but the right thing for the right reasons, or our moral obligations and understanding of people and the caring of people in this world. We've got a statutory obligation because the law requires us to look at things that way, and we can all benefit from it from a business perspective, financially, and in the success of our organization, if we really focus on these as part of our culture in the way that we operate our businesses, opposed to looking at these statutes and these obligations as being some sort of barrier to our success. It is exactly the opposite. So what do we consider to be a disability? A disability is defined by the Act as a physical disability, an infirmity, a malformation or disconfiguration, conditions of mental impairment or developmental disabilities, learning disabilities, mental disorders, injuries or disabilities of which benefits were claimed or received under the Workplace Health and Safety Act. So people are injured at work. Disabilities may be visible or invisible. They may be continuous. They may be intermittent. They may come and go. They may be temporary, and they can vary in severity from time to time. And so information about a person's disability is personal, so must be treated with privacy and confidentiality. But it also means we must always be cognizant or aware of the fact that they exist, so that we can make decisions in our business on how to act and react and accommodate people with disabilities. So we have to create, when you have an AODA system in place, you have to create a policy. So the organization is committed to providing exceptional and accessible service to our customers. This isn't a sample of a policy. That our organization is committed to providing exceptional and accessible service to our customers. Our services will be provided in a manner that respects the dignity and independence of all customers. The provision of services to persons with disability will be integrated whenever possible. Persons with disabilities will be given an opportunity equal to that given to others to obtain, use, or benefit the services provided by and on behalf of our organization. So I wrote this policy, like, I don't know how, 2005, when AODA was introduced. And this one was written as a generic one, so that every company could take this sample policy and say, do we have a written policy published someplace, and does it look like this? And how can we take this, one paragraph, and can we modify it to be more specific to our company? So the AODA policy then goes on to require that there's some defined form of training, who gets it when they get it, the use of assistive devices, service animals, and support persons. It has to identify the notice of temporary disruption. So for example, when the elevator's down or the signage is out, the website's down. The policy has to have some form of feedback, so that people who are concerned that our policy doesn't work can give us some feedback about how it affected them, and we can improve it. And then we have to have a notice of format availability of documents, which basically means people with visual impairments, where do they get a copy of the policies and all the things that happen in our company. So diversity, equity, and inclusion, why this matters. Companies that are diverse, equitable, and inclusive are better able to respond to the challenges in their marketplace. They can win top talent, attract great people, and they can meet the needs of different customers. I mean, I just can't imagine a bank branch, for example, in certain communities not having tellers, customer service representatives that don't speak the prominent language, in that community. And so only hiring people that speak English in a community that is Indian or Italian or Chinese doesn't make any sense, to not have people that speak those languages in that community. With DEI in mind, Canadian employers are considering how to better support their employees more than ever, with a focus on attracting, motivating, and retaining a diverse workforce. So again, this is sort of the written words that I talked about just earlier, that we can be better companies, more profitable, more sustainable, attract better people, have better employee retention when we take DEI in mind in creating a better workplace. Okay, so we look at things like gender diversity, age diversity, ethnic diversity, physical ability, and neurodiversity. These are all different things that we look at when we talk about diversity. And I got to say this, that I think that television, movies, media, and politics, and particularly US politics, have really sort of grayed the water. And, they've made it sound like it's a bad thing. And in the United States, for example, some special programs that were trying to create diversity in enrollment and accessibility to universities have been found unconstitutional. They're not unconstitutional in Canada. The Constitution is written in the United States. They take it very literally. If the words in the Constitution there say something very specifically, regardless of what is probably the right thing to do or the intention to do, people always challenge things under the Constitution, and some strange things happen. And so some of the DEI programs, for example, in the United States, have been removed for access to creating more diverse populations in universities and colleges. We really need to look at this in a way to say, how do we become a better workplace? How do we make better things? How do we provide services to our customers differently? How can we get a bigger customer base by thinking about the diversity of our customers and the manner in which we provide our services to them? How do we attract some of the smartest, best, most committed employees in the world? Well, we create a workplace where everybody is eligible to apply, can apply, gets equality and the opportunity to be reviewed and chosen, and so that the best people can find work in our organizations. So equity refers to fair treatment of people so that the norms, practices, and policies in place ensure identity is not predictive of opportunities or workplace outcomes. In other words, equity means that if we create equal opportunity to people, then we can get a more diverse workplace. Equity differs from equality. It differs from equality, sorry, in a subtle way, but an important way. While equality assumes that all people should be treated the same, equity takes into consideration a person's unique circumstances. So equality means equal. And equity means that we're going to make some changes in the circumstances so that the opportunities become equal. Okay. Inclusion refers to how a workforce experiences the workplace and the degree to which organizations embrace all employees, enables them to work in a meaningful contributions. Companies that are intent on recruiting a diverse workforce must also strive to develop a sufficiently inclusive culture, such that all employees feel their voices will be heard. Inclusion in a workplace means listening to everyone, understanding that we all don't see the world in the same way, that it is really quite incredible. And again, I look at the political discourse that exists and that we read about and we see in the media all the time, how some people see an event and say, oh, that was good. And other people see an event and they go, oh, that was really bad. And it's the exact same event. And when we include everyone in our decision making, or at least we include people and allow them the opportunity to speak their mind and to tell us the way that they view the world and they view events and they understand things, we can make better decisions. We can make much better decisions. You know, I always find things like benefits. You can have one company that has this benefit package A, and all the employees think that it's the best benefit plan in the world. And then we can have another company that has the exact same benefits plan, but for some reason, maybe because there was a prior merger or acquisition or something, and the company came together, that one of the companies had a better benefit plan than the other, then all of a sudden benefit plan over here, benefit plan A over here, doesn't look good at all. People say, well, wait a second, the company we merged with all had better benefits, and the people who came in lost some of their benefits. And so we've got a perspective over here that says this benefit plan is terrible. And yet this group over here says, this is really good and is way better than what we had yesterday. Yet they're the exact same things. And by allowing people to come into the room to tell us their perspective, tell us why they feel the way they feel, why they understand things the way they understand them, allows us, as we're more inclusive, to engage people in the development of our culture and the decisions that we make. So when all voices are heard, then our organization can unlock the power of that diverse workforce. So DEI and equity for all. So we talked about human rights legislation today. We talked about employment standards yesterday. We talked about employment equity, the federal legislation today, where we're trying to get our employee group to match the diversity of the communities that we live in. And we talked about AODA, which is specific legislation that is intended to remove barriers and create opportunities for people with disabilities. Okay, we got 45 more minutes. Last section. This all also falls into the areas of privacy. So parts of privacy are considered under the Charter of Rights and Freedoms. So the Charter of Rights allows us to protect our own personal information, and the parts about the freedoms allows us to have freedom of access to information. So PIPEDA is specifically the Personal Information Protection and Electronics Documents Act is particularly designed to help us protect our personal private information when it's included in documents in the business that we work in or in the services that we receive from someone when they need our information. So PIPEDA legislation, by the way, is a federal legislation that came from the Charter of Rights and Freedoms. It was written into federal legislation, and the federal government said, with the support of the charter, every province needs to have some kind of law around personal privacy. And they defined what kind of information need to be kept private and who need to be kept private. And they said, you can use ours, you can use the federal one, just use it. And so some of the territories and so on, you just use it. Or you can write your own, so long as it adheres to the same principles, but you can write your own because you're going to have different terminology and things that you want to use about, your commission and how you make a complaint and how it gets resolved. That's all fine. So different provinces approached it in different ways, but they're fundamentally the same. So the PIPEDA protects personal information in the hands of the private sector organizations and accompanies with guidelines for the collection, the use, and of that information through the course of the commercial activity. So in other words, it goes like this. Private sector organizations across Canada that collect or use or disclose personal information in the course of their commercial activity. The law defines what a commercial activity is as a particular transaction or an act or conduct or any regular course of conduct in that commercial character, including the selling, bartering, leasing of or membership, fundraising lists. So all of these things are included and covered under PROPITA. So if you do those things, you sell something, you buy something, you provide a service, you support a charity, you create a donor organization, then the information must be protected. Alberta, British Columbia, and Quebec have their own private sector privacy laws that have been deemed substantially. So I said to they went out and they took the PROPITA, the federal legislation, then they wrote their own. Organizations subject or to a substantially similar provincial privacy laws are generally exempt from federal PROPITA. So if you've got a provincial law, you don't have to adhere to the federal law. You apply to your province. Deborah, you have a question?
I do. I think it falls into here. One of the questions that some of my clients have me ask is, does the candidate have their own transportation because the client is not on a bus route? And I actually make up a document kind of summarizing some key questions, and that I ask the candidate and they respond to. And that's one of them that I do share back with my client, yes or no, if they have their own transportation. Is that legal or not?
Yeah, sure. So we're gonna. You always ask the question. I think, like, probably if we got you ask good questions because you're anticipating what's coming down. It really has to deal with the purpose of which the information was collected. So, and again, we're gonna get to this in more detail on probably even the next screen. I'm not sure. When we go to collect information, we have to disclose to the person that we are collecting this information for a particular purpose. And the law requires that we only use that information for the purpose of which it was originally intended for. And that we can't use the information or sell the information or offer the information for any other purpose. But if the purpose of you collecting information about whether or not a person has their own method of transportation, hey, I own a home care company. We've got 350 nurses or caregivers and another 200 nurses, and they go out in the community and they go to people's houses. I got to know, how long does it take? How do you get around? How long does it take you to get from your home to this place and from that place to the next place? And we don't say to people, you have to have your own transportation. But we do say to people, it's important that you can get there on time. So I can't send a person in the morning to one address and then they have a transportation to another place. I got to know, are you taking public transportation or are you taking your car? And then our GPS tracking system and our whole scheduling system tells us if they're taking public transportation, it takes them 45 minutes. If they're taking their own car, it's going to take them 15 minutes. I got to know that. It's a bona fide occupational requirement. I'm allowed to know this because I got to get people to certain places on time. So I have to know how they're commuting. And I don't give preference to people with their own car. I simply schedule people to places that they can get to on time. And so you can ask the information, but you can only use and disclose the information for the purposes of which it was intended. So if you asked everybody, do you have your own method of transportation? And everybody provided it to you, but not every job had some sort of bona fide occupational requirement where that was relevant, and you gave that information to every customer, that would be a violation of the law. But if the purpose of which you intended it for was to figure out what, like I have a customer that I do consulting for in Brampton that says they will not hire inside salespeople who have to commute more than 55 minutes. Because in their experience, people who have to commute more than 55 minutes are highly likely to be late for work and miss work more often than people who are within 55 minutes. I've had lots of conversations with them about how'd you come up with that number? Is that reasonable? And all kinds of stuff. And they basically came back and said, hey, listen, we'll listen to reasonably accommodate people who live further than 55 minutes. Like if a person says, I live an hour and 20 minutes away, but my my kid goes to U of T downtown, my wife works at Queen's Park, and I need to get to, I live north of Brampton, I got to drive right by the office, they're going to drop me off, then they're going to continue downtown, and, this is not just me, and they might say, well, the chances of this guy getting to work on time are pretty good, because his wife and daughter got to keep going by here to get on their train or to drive downtown. There might be some weird circumstances that they will accommodate them. But, this particular company has decided it's a bona fide occupational requirement that you be able to get to work within 55 minutes because they can't afford to have their sales desk not open at 8 o'clock in the morning twice a week from somebody who's in their inbound sales desk who can't get to work. I don't know if it would pass the smell test or not. They seem to think it does. I think maybe it probably will. So the only point is here is with privacy laws, is that if you collect information, you got to collect information for a purpose. And once you've collected it, you can only use it for that purpose, and you can't disclose it to other people for any other purpose. And if you're doing that, you're perfectly fine. So back to the screen again. Great, good question. Ontario, New Brunswick, Nova Scotia, Newfoundland, and Labrador have also adopted substantially similar legislation regarding the collection and disclosure of personal information. In Ontario, for example, they've come up with three different approaches. First off, they created the Information and Privacy Commission of Ontario. They created this thing called FIPA, the Freedom of Information and Protection of Privacy Act. So this is the part of the act that says that governments must disclose information if they're asked for it. So that's the FIPA part. That's the access to information. They came up with the MFIPA. They made it mandatory that municipalities provide freedom of information. So the FIPA is for provincial government and provincially regulated businesses, provincial government and provincial special operating agencies like prisons and Service Ontario offices, that kind of stuff. Then the MFIPA, they made it mandatory that municipalities, cities, and towns provide access to information. And then they came up with the FIPA PHIPA, Personal Health Information Protection Act, which goes the other way. And it's like, okay, now if you're collecting health information about people and providing some sort of health service, they came up with all kinds of rules on how you must protect that information so that other people can't get access to it and that it's only used in the manner for which it was collected. So Ontario doesn't mean every company in every private sector has got an obligation to have privacy policy, but if you're collecting anything that could be used from a health services standpoint and you're in the private sector, then you've got some obligations. So here's the 10 principles of privacy. Number one, whoever's collecting the information must be accountable for all aspects of the collection and use of that information. As I mentioned before, they have to identify in their policy. They have to identify why they're collecting this information, when it's used. Then you know this part. Number 3, that if you're going to collect certain information, particularly anything that could be related to health services. So if you were collecting somebody's health card number and you need to have it in your human resources office for a person, or you're collecting information about their benefits, their health benefits, then you have to protect that information and you have to ask for consent to collect the information. And when you ask for consent, you have to identify the purpose. We're collecting this information for your health benefits purposes. It's going to be used only for the purposes of your health benefits card and for your family's benefits. And it's only going to be used for that purpose. And that we're going to limit the collection of information. We don't need any additional information from you except for that express specific information for that express specific purpose. Number 4, then we have to limit the use of it. Now that we've got it in our files, we have to make sure that nobody's using it for any other purpose, that we're not going to look it up to see, do they have a family, or do they need, we're going to give them a promotion or not give them a promotion because they're married and we thought they're going to have children or something. So we have to limit the use of it and the disclosure of it. We have to make sure, we have an obligation to ensure that the information that we collect and that when we keep it, that it's accurate. There's no point in collecting information and using it for express purpose and then it's out of date. We have to provide safeguards. We have to tell people how we're going to, and we have to have in our policy, how we're going to make sure. So for example, in my healthcare company, everything is covered under PIPEDA because it's all healthcare information. And, we make sure that when we use cloud-based services, that all of the cloud-based services that we have are adhering to the safeguards so that we can ensure its safety. Nothing is perfectly, on the internet, nothing's perfectly safe, but there's a higher standard when it comes to health, protection of health safety than, say, for example, what might be used for your Air Canada ticket or your Loblaws membership card. Not to pick on them, I just mentioned those companies. But health, we have to have special safeguards in place for health data. We need to be open with the people that we collected the information from about the fact that we have the information, and also open to them about whenever we have concern that there might have been a breach of data. So this is why you get notifications from companies from time to time saying, on such and such a date, we're concerned that there may have been a data breach and that this is the kind of information that might have been there, and we're monitoring it and we're doing this and we're shut things down or whatever they're doing. So you need to be open to people, so if I lost my laptop on the way home from work and I had information on my laptop about some of our home care customers, I would have to declare to everybody that I lost my laptop and their information might be breached, which is again why we don't keep information on our laptop. We keep it in a secure, safeguarded, cloud-based service that meets all those higher standards of safety. We need to give every individual access to their information, so that if they say, hey, what do you have on file? Can I see what you have on file? We have to allow them to have access to their personal information. And then we have to have a method for people to challenge us. So a way for people to make complaints if they think that their information has been violated. So what information would be considered personal? Age, name, ID, SIN number, ethnic origin, blood type, religion, that would be considered. Now, by the way, I also want to make sure that if you're federally regulated, all those things matter. If we're dealing with a health consideration, this is the kind of information in Ontario. If you're dealing with a municipality or a government, like a municipality or a town, all of this information. Opinions, evaluations, comments. So when we do surveys, we're supposed to keep that information. Any disciplinary actions that we had with employees. Employees' files, their credit records, their loan records, their financial records, their medical records, any dispute that they might have had with the company needs to be kept private. Intentions of examples to change jobs. Now, here's the thing, right? When you're in the search business, the recruitment and search business, our business is to collect information about people. Our business is how much money do you earn? How much money do you want? Where do you want to work? What's important to you? So we're collecting this information all the time. So the important thing to remember is that we really shouldn't be disclosing this information that we've collected to our customers until we've got permission from the candidates to disclose it. Now, again, I just want to say that all federal government federally regulated companies have to protect all of this stuff. And in the provinces, there's some limits. Ontario has said it only applies to municipalities. It only applies to the provincial government. It only applies to provincial operating agencies, and it only applies to medical issues, medical records. Whereas a federally regulated industry and other provinces might have written theirs differently. Everything, name, age, religion, whether you own a car or not. So, back to your question about, are you allowed to disclose whether or not they have a car? Well, first off, that's not medical in Ontario, so it's not really protected. But in keeping with the principles of privacy legislation, you really should say, hey, I'm collecting this information for the purposes of finding you employment. And when there's a bona fide occupational requirement that they need to have information about getting a job, I'm going to disclose this information to help you get a job. So you're not in violation of the law, the privacy laws, because in Ontario, it doesn't, as a private sector, provincially regulated private sector company not providing medical services, it doesn't specifically say you can't, but we all attempt to adhere to the same standards. Collect information, ask for permission to collect it. Once you've collected it, make sure that you're collecting it for a specific purpose. Only use it for the purpose of which it was intended for. Don't disclose it unless it's for that specific purpose. Protect it, make sure that there's no violations. If there are violations, deal with it. If there's a leak, tell people, don't sell it. Okay, your province has adopted another privacy legislation, therefore PIPEDA does not apply within that province. Well, federal PIPEDA does not apply to you. Your provincial PIPEDA legislation does apply to you. Know your provincial PIPEDA or similar legislation to know what aspects of it do apply to you. Which of the following statements about consent is false? I didn't talk to you about this, so we'll answer it. Organizations can generally rely on implied consent. No. Implied consent means we're collecting this information, and unless we hear otherwise, we're going to use it. No. Your credit card information has just come up for renewal, and we have it on file. By purchasing something from us, we can keep it forever. No. You have to say, do you want us to keep your credit card information for future use only for purchases from this website? Yes. So implied, there's no allowed implied consent. The consent mechanism chosen should be clear and unambiguous. Yes. Now, you've been on the call before where somebody said, hello, Mr. Jones. In order for us to go forward with this contract, we need to get your consent to information. For the next 30 seconds, we're going to be recording this call and we're going to ask you specific questions. Are you okay with that? Because we need to record your consent. Yes. Okay, so we're going to come to your house. We're going to do this thing. Yes. Do you live at this address? Yes. Is there, yes. Will there be someone over the age of 18 in your house? Yes. Thank you very much. Consent is done. Recording is complete. So they've asked about your age. They've asked about your address. They've asked for your thing. They record it. So the mechanism doesn't have to be a tick box or a handwritten signature or a signature on the form or something. There's lots of different mechanisms that you can collect the information, so long as you're clear and unambiguous that you are collecting information and that they agree to that method. Consent can be obtained in a number of different ways, such as in person, by phone. Yes. There we go. All of these legislations for PIPEDA, whether it's provincial or federal, have got a complaint making mechanism as part of the legislation, and they all pretty much follow the same thing. You first go complain to the organizations. Hey, I think you collected my information and used it improperly, or I'd like to get access to my information and you didn't show me what my information was. You go to the company. If the company should have a published mechanism to make a complaint. If you're not resolved through that mechanism that the company published, then you go to the Privacy Commissioner of Canada or to the Privacy Commissioner of your province. You file your complaint there, then they use what's called an early resolution officer. Then the Privacy Commission goes to the privacy officer in the company. They try to resolve it that way. If it can't be resolved, it could go to court, but it's always resolved either through the company or through the early resolution officer. Nobody wants to go to court to fight over information. Damn, just give them the information or get rid of the information. We've got this other issue that we could talk about all day long. We're not going to talk about it all day long, but be considerate of this. Social media has got a whole bunch of traps. If you're giving people, here's a perfect example. You're a recruiter, you're a headhunter, you're recruiting people. So you go to social media sites and you find people in groups and then you try to connect with them. You're hiring somebody and they make an application, so you start to scour their LinkedIn account and you find out that certain information on their Facebook and their Insta account is public and their Twitter account. So you start reviewing all of their personal private stuff that may or may not be work related. During COVID-19, there was all kinds of questions about, are you sick? Did you test? Can you come to work? Are your children sick? Are you married? Is somebody in your family sick? My goodness. In the normal context, you would never be able to ask somebody, is somebody in your family sick? Like, you would just never be able to ask that. But there were special considerations that we need to know. Have you been in contact with somebody who's been sick? And so there under our workplace, under our business practices and ethics, we're going to talk a lot about more about social media policies, privacy policies around social media accounts. But just remember this, that I want to say one more thing. In the recruitment business, it makes a ton of sense that you use your social media to help recruit and find people. It makes a ton of sense. It makes a ton of sense that you build your network up, that you share jobs, that you become a thought leader, that you tell people who you are, that you help people and give them advice, that you have access to groups of people so that you can broadcast things to them and attract them to your attention. Makes a ton of sense. Just be aware of the fact that we've got an obligation to tell our employees that we're monitoring their activities. Be aware of the fact that if you start judging people based upon their social media and you wittingly or unwittingly, knowingly or not, start to select people or reject people based upon their family status or their culture or their opinions about certain things that are in prohibited grounds, you could be violating the law. So, we want to encourage our employees to take advantage, to be better recruiters, to take advantage of their Facebook account, their Twitter account, and their Insta account, and their LinkedIn account, and to broadcast jobs and to post things everywhere and to build up their network and to be so that they can fill jobs better, faster, quicker. But also remember the trappings. We've got privacy issues. We've got privacy issues. Like once they start to build up a network, and you encourage them to do it at work, is that your network or is that their network? Be clear about what your rules are. You're allowed to or you're not allowed to do this at work. If you do it on the company computer, the company phone, we can monitor your activities. If you do it at home after hours, do it under a different account. Or don't hook your Facebook to this because we can look at, you're going to have to allow us to look at it. If you're going to do it at work, try to post our jobs, then we're going to be allowed to look at your Facebook stuff. So make sure your rules are clear. Make sure that you've communicated it well. Make sure that you only use it for the intent and purpose of which it was intended. And don't be scouring through people's social media just to find out what they're like behind the scenes and what they do at night. So this is not part of the exam, but it is part of the broader topic. I wanted to bring it up to you and let you know that we will talk about it in more detail on the business practices and ethics course. I promised you 15 minutes early. We're 12 minutes early, 13 minutes early. Sorry, that puts me ahead of schedule, but behind schedule. It gives us time for everybody to stay on the line and ask me more questions if you wish. I'm going to open it up to you. So, Deborah, I see you've unmuted. Do you have a question?
I do. Are we allowed to ask where a person lives? And the reason I ask that is because some of my clients say, I only want people who live within the geography. I don't want people who live elsewhere in Ontario who have to relocate. We've had problems in the past with them being homesick and they leave, or they can't find housing accommodation once they accept the job to relocate to our region. Are we allowed to ask about their address or where they live?
Well, the examples I gave you earlier about my home care company, there was a bona fide occupational requirement. You're allowed to do that. I would say that all you really need to do is you have to establish that there is a relationship. First off, race, creed, color, religion, sex, sexual orientation, family status, place of origin, criminal offenses. Asking a person where they live doesn't necessarily breach any of the 11 prohibited grounds. Okay, so first off, it doesn't do that. It could be interpreted to do that. Are you asking whether or not you live in a rental apartment or you own your home? Are you asking whether or not you live in a rich neighborhood or a poor neighborhood? Are you asking whether you live in, what I'm saying is, by asking a person where they live, it could be interpreted that you're trying to figure out whether they live in an ethnic community. It could be interpreted to find out what their family status is. It could be interpreted to mean something else. So it doesn't. You're talking about commute time. How reliable are you going to get to work? And commute time is not a prohibited ground. If you said to them, do you have any kids that I need to worry about that are going to get sick and you're not going to be able to get to work on time? Because, man, if you live 45 minutes away and those kids can't get on the bus till 8 o'clock in the morning and you got to be here at 8:15, how are you going to do that? Well, that's prohibited. You're asking about family status. So the question has to be, how far do you have to commute, and can you reliably get here by 8:30 in the morning or 8:15 in the morning? And if in Canada, winter roads and so on, if you live an hour away, it's reasonable to predict that you're going to be late more than a person who lives 5 minutes away. Not necessarily. The person who lives 5 minutes away might be extremely unreliable. But it's not a prohibited ground, distance to travel. That's not covered under the Human Rights Code. So if the question is a thinly veiled question to determine whether or not you're trying to find out about whether they live in a cultural community or whether they're married or whether they have children, then it's not allowed. But
Right.
if it's on face value, we don't support people, want to pay for people, or take the risk of relocating people. It's our policy. No problem.
Okay.
No problem.
Good.
We don't want to take the time to wait. Now, a person might turn around and say, hey, look, I can move here tomorrow and live at my mother's house. Like, don't you worry about it. Then I think you should, from a business standpoint, you should probably say, well, this is a really freaking good candidate. They can go live at their mother's house tomorrow, or their best friend's house, or their ex-wife won't kick them out for another month or something. I don't know, whatever their story is. But if they can overcome your concern, then, I think you should listen to them. But as soon as it starts to get into, is it the ex-wife? Is it the mother? Is it the children? All of a sudden you're collecting information that you're not supposed to collect and you're not supposed to consider. But distance for travel is not a prohibited ground, so you can ask it.
Okay.
Okay.
I have another question, if the others don't mind me asking.
Yeah.
Can we, in a job posting, require the applicants or successful candidate to already have a valid Canadian social insurance number at the time of their application?
Absolutely.
Okay.
You can say candidate must be eligible to work in Canada and have a valid social insurance number or work permit. No problem.
Okay.
There's no discrimination against that because you have got no obligation to recruit internationally, and
Mhm.
you've got no obligation to break the law to hire people. So it's not a problem.
If a client
You would be breaking the law if you hired a person without permission, correct?
Correct. If a client, writes a job offer to a candidate and says you have to accept or decline within 5 days, like, if you don't accept within 5 days, it's null and void. Is that a best practice, or is there anything, I don't know if it's best practice only or if there's a legal requirement for all clients to have a 3-day or a 5-day clause or any clause whatsoever? Because some don't have a clause, and then the
Yeah, that's
candidate
it.
drags on.
Yeah, a best practice is to always have a reasonable time frame, and it needs to be reasonable. If the time frame is too short, then you can get yourself in trouble because you could say, hey, you caused harm to me. I quit my job. You made an offer to me and I quit my job, and then I got this piece of paper back to you a day late, and now I'm screwed. So
Okay.
it should always be a reasonable time frame. If the time frame is too quick or too short for them to go and get legal advice or to get a consultant or counsel, then that's a problem. But having an open-ended offer is also a problem because the person comes back 3 weeks later and you just assume they're not there anymore, and all of a sudden, so it is a best practice to always say this offer is valid until. However, lots of people don't have that because what they do is they make the offer verbally, and the person says, I don't know. And they say, okay, when do you think you're going to know by? And they go, okay, we'll know by Friday. And then they call them on Friday and they don't respond. And they call them on Monday and they don't respond. And then the company then sends them a thing saying, we agreed that you were supposed to be here on Friday, and you didn't. I tried to get a hold of you on Monday. We'll give you until 5 o'clock today, otherwise we're gonna have to move on. That's the same thing. But that
Mhm.
just requires you to take some action there to say, hey, this is, we're not hanging on to this any longer, so it's pretty much the same thing, but it's a good practice, particularly if you're making lots of written job offers without doing it verbally uh, to have a poison pill deadline on it.
Thank
But
you.
that has nothing to do with human rights or other aspects of the law.
Mhm.
Best practice. These guys are nodding their heads like crazy, so it's okay for you to keep asking questions because they seem to be happy with the questions you're asking, Deborah. Joey, Navneet, you good?
Yes, all good.
Okay.
Yeah, all good.
Okay, good. Deborah, any more? Okay.
I'm good, thank you.
I gave you my email address yesterday. It's steve.jones@bell.net. steve.jones@bell.net. I got lots of other email addresses. That's the one that everybody can remember and write down when I say it quickly. Feel free to send me any questions you have whatsoever about anything we talked about today or yesterday. There will be a recording available for you to go back and review. Remember that the exams are multiple. It's important you get your CPC. It's important because it shows your commitment to your profession. It's good for the industry. It's good for you. It's good for your business. It's good for your company. It's important you get your CPC. It's important that you put those letters after your name on your email signature and your business card. Tell people you have your CPC, differentiate from them. But what's more important is that you remember, it's important you pass the exam. Remember, it's a multiple guess exam. We don't ask you to memorize tons of stuff. It's almost every question has to deal with the logic and concepts that we talked about today. They're not going to ask you to calculate something to know the difference between Alberta and British Columbia on vacation pay calculations or something. They're not going to do that. But they are going to ask you, is vacation pay a thing? And, is everybody entitled to it? Those kinds of questions. But what is important is that you remember and understand the types of things that we're talking about because they're different and they change. And politicians make promises and they run in elections and then they introduce legislation and they repeal legislation. Know that these things exist. Know that this is something you probably should check on. Just don't assume that it's okay. My customer's doing it, so therefore I can do it. Just know that these concepts exist, what they're intended to do. Use your spidey sense to say, I think I should check on this. I'll send an email to ACSESS. I'll look it up on the website. I'll log into the Human Rights Commission. I'll go to the Employment Standards Act. I'll download that thing from the official place. Check on it. Make sure it hasn't changed. Make sure it's still right. If it feels like it's wrong, it's probably wrong. Go take a look, And I think, Deborah, was a good point. And we deal with this a lot in the business practices and ethics cases that once we go beyond the legislation, what's the best practice? And so we're going to talk about contracts, employment contracts and job offers and things in that session because it goes beyond the legislation. And so just know that they exist and know what types of stuff you should probably check on. And when you do that, you're way better than everybody else. You're just doing a better job than your competitors who don't, because it's unbelievable what people think they know, never check, and keep on doing the wrong things over and over and over again. And it's when we take a step up and we do a better job, we get more customers, we get more employees, we have fewer problems, we have little less turnover, more satisfied candidates, more satisfied customers, more satisfied employees. we have less stress in our life. We make more money. All good things come from knowing the issues, not knowing the answers, but knowing the issues that we should find the answers to. Okay, guys, always a pleasure. 4 o'clock on the nose. Have a great day.
Thank you.
Thank you.
Have a good
Thank you
week.
very
Bye-bye.
much. All right, take care.
Bye.
Bye.